According to the Sixth Amendment, criminal defendants have the right to the assistance of counsel. Keep in mind that the Bill of Rights originally did not apply to the states. Only specific amendments have been incorporated through Supreme Court case law to apply to states. Although all criminal defendants have the right to the assistance of counsel, the right to the appointment of counsel is not actually based on the Sixth Amendment, but it's based on the Equal Protection Clause. I also want you to keep in mind that at the time that the Constitution was ratified, there were no state law licenses. Therefore, the original meaning of the word counsel did not mean licensed attorney. States have given members of the bar a self-serving monopoly over the practice of law, depriving citizens of the constitutional right to counsel of choice. Even if you don't trust members of the bar who are also officers of the court, you don't have the right to hire whomever you want to represent you. You are relegated to hiring a random stranger out of a phone book who charges $500 an hour simply because he or she is licensed. Despite giving members of the bar a self-serving monopoly over the practice of law, the state has contemporaneously refused to effectively regulate the cost of legal services. As a result of this monopoly, most criminal defendants don't have any access to legal representation unless one is appointed by the court. And given the unnecessarily complicated court doctrines created by attorneys, criminal defendants cannot receive a fair trial without representation by an attorney. The American court system is to a large extent an illegitimate wealth siphoning racket. In addition to the Sixth Amendment's right to the assistance of counsel and the right to equal access to counsel under the Equal Protection Clause, there is also a right to counsel under procedural due process. The 14th Amendment says that no state shall deprive a person of life, liberty, or property without due process of law. Congress has the authority to create legislation to enforce the 14th Amendment. I think it's time for Congress to create a federal law requiring states to appoint counsel in all criminal cases, including misdemeanor cases. As I previously stated, the Bill of Rights did not originally apply to the states. Only certain amendments were incorporated to the states through Supreme Court case law. In the case of Powell versus Alabama, the Supreme Court held that states were required to appoint counsel in capital cases. The Supreme Court held that the right to be heard would be, in many cases, of little avail if it did not comprehend a right to be heard by counsel. Even the intelligent and educated layman has small and sometimes no skill in the science of law. He requires the guiding hand of counsel at every step in a proceeding against him. Without it, though he may not be guilty, he faces the danger of conviction because if he does not know how to establish his innocence. In the case of Gideon versus Wainwright, the Supreme Court held that the appointment of counsel is a fundamental right, essential to a fair trial and necessary to safeguard liberty. However, the court limited the right to counsel in state courts to felony charges. In the U.S. Supreme Court of R. Singer versus Hamlin, the U.S. Supreme Court held that the right to the appointment of counsel could apply to misdemeanor cases, but only if those cases involve incarceration. The problem is that the collateral consequences of a misdemeanor conviction may be just as severe, if not more, than the actual possibility of incarceration. A misdemeanor conviction can bar eligibility for many professional licenses, render an individual ineligible for public housing, make the offender ineligible for health care programs, require enrollment in a sex offender registry, lead to deportation, and affect child custody, food stamps eligibility, and the right to vote. In the concurring opinion, Justice Powell stated that the consequences of a misdemeanor conviction, whether they be for a brief period, may be deplorable conditions in local jails or the effect of a criminal record on employability. These consequences are frequently of a sufficient magnitude not to be casually dismissed by the label petty. Serious consequences may also result from the convictions not punishable by imprisonment. Stigma may attach to a drunken driver conviction or a hit and run escape. Losing one's license is a more serious consequence for some individuals than a brief stay in jail. Moreover, he took issue with the majority opinion demarcation of indigency, stating that even those who are not technically indigent but who are barely self sufficient economically would still be unable to afford counsel and would therefore be deprived of a fair trial. Given overburdened court dockets, judges commonly defer to prosecutors. Left to the devices of unscrupulous prosecutors, criminal defendants believe that they have no choice but to accept plea deals. What's more, criminal defendants are routinely summoned to appear in court without a probable cause determination. According to case law, the Fourth Amendment does not require courts to make a probable cause determination in misdemeanor cases. Many of these cases are prosecuted based solely on a criminal complaint without an information or indictment. According to case law, the Fourth Amendment is not implicated because a court summons is not considered a seizure even if the defendant is ordered to appear under threat of arrest. In the case of Murphy versus Lynn, the Second Court of Appeals held that a misdemeanor criminal defendant who had faced a Fourth Amendment seizure even though there was no actual arrest. The court held that because he was summoned to appear in court multiple times, the Fourth Amendment had been implicated because he faced travel restrictions. Given the volume of misdemeanor cases exceeding the number of felony prosecutions, prosecutors often resort to assembly line justice. 70% of criminal defendants plead guilty without counsel in proceedings that often last under 3 minutes. Misdemeanor prosecutions are a well oiled machine. Due process be damned. The court system is a system of pleas, not a system of justice. Simply by eliminating the possibility of incarceration, states are permitted to deprive criminal defendants of the right to counsel and railroad them into accepting oppressive plea deals. In Alabama versus Shelton, the U.S. Supreme Court held that uncounseled convictions are inherently unreliable. As local governments face budget cuts, courts seek additional revenue sources. Municipalities are increasingly imposing user fees on criminal defendants to generate additional revenue. Fines and related fees may provide a better source of revenue than property sales and income taxes. Even for minor offenses, criminal defendants may be charged for the cost of a police investigation, probation supervision, jail stays, and court overhead. The worst part is that even for crimes which are punishable by fine only, there is nevertheless the possibility of incarceration in all criminal cases for non payment. Criminal defendants who have the assistance of counsel are 5 times more likely to have their charges dismissed. Clearly, we have a two-tiered system in which punishment is most likely to fall on those who cannot afford to hire an attorney. Prosecutors use the threat of jail to extract money from unrepresented defendants and to maintain inflated conviction rates. Although the Sixth Amendment is one vehicle for securing the right to counsel, we also need to consider the 14th Amendment's right to equal protection and procedural due process. Without the assistance of counsel, criminal defendants, whether they be felony or misdemeanor cases, are not being given a meaningful opportunity to be heard. A fair justice system would require states to provide the assistance of counsel in all criminal cases, not just felony cases. A lack of wealth should not determine one's treatment by the court. The fact that court dockets are overburdened is no excuse. If states cannot afford to provide the assistance of counsel, States should either decriminalize victimless crimes and prosecute those cases as civil matters or provide a free market for legal services. It is their self serving monopoly over the practice of law which has rendered legal services inaccessible. Courts should not have the power to summon criminal defendants in misdemeanor cases without probable cause and without the assistance of counsel. The cost of hiring an attorney for just 1 hour would usually exceed the cost of the fine itself. Criminal defendants should not be forced to either go in debt hiring an attorney or assume the involuntary servitude of maintaining their own defense. The assembly line nature of misdemeanor prosecutions is a racket which is making people's lives a living hell. People are routinely harassed by law enforcement and held into court without the ability to defend themselves. Congress has the power under the 14th Amendment to enact a statute requiring states to provide the assistance of counsel in all criminal cases, including misdemeanor cases. States and local governments should not be allowed to use the court system as an instrument of oppression, siphoning wealth from the vulnerable public without fair trials. We need a federal law putting an end to this tyranny.